Good morning, and please be seated. Today is October 14th. This is the time set for oral argument in our cause number CR240441, State versus Sanchez Rodriguez. I would ask that out of respect to counsel and to the court, that everyone in attendance in the courtroom please make sure your cell phone is silent or turned off. Each side is allotted 20 minutes to present their case. You are not required to use all of your time. If you wish to reserve some of your time for rebuttal, you can do so, but it's up to you to make sure that happens, because the clock will only show your total remaining time. These proceedings are being live streamed and will be available on our website for viewing. And with that in mind, please speak into the microphone when you approach the podium. Identify yourself and the client that you represent. We have read the briefs, we've studied the record, and discussed the case in conference this morning. And please keep that in mind as you present your case. You may proceed.
Your Honors, I'm so sorry. My name is Jessica Zachary. I represent the appellant and Selmo Sanchez Rodriguez. In the appellant's opening brief, as you guys have read, there were three main arguments raised. The first argument, whether the trial court abused its discretion by either rejecting or withdrawing the appellant's guilty plea without providing any reasoning on the record as to the reason for that decision. The second issue is whether the trial court abused its discretion when it allowed the state to amend the indictment in the middle of trial, thereby changing the nature of the allegations. And the third main issue is whether the appellant was improperly sentenced on count 2, requiring resentencing. Given that the state conceded error on the third issue, I don't plan to address the Apprendi sentencing issue unless this court wants to hear more on that issue.
It becomes moot, doesn't it, if we agree with your position on the first issue, on the vacating of the
Yes.
of the plea?
Honestly, I think both of the next issues become moot if the court agrees with me on the first issue.
Okay. Well, let's start there, and I have a question for you.
Okay.
Did jeopardy attach when the court said, I find that the plea is knowingly, voluntarily, and intelligently entered, and I enter it of record?
I was thinking about that when I was reading through the state's response. Honestly, I think jeopardy probably did attach at that point in time. I unfortunately have to agree with the state that I failed, or the appellant failed, to raise that issue thoroughly in
Does that
arguing.
matter? Can you waive a double jeopardy issue? Or is it, as our case law say, that double jeopardy is fundamental?
I don't think you can waive that issue. And so I do think that jeopardy attached when the court accepted the plea agreement prior to later on withdrawing the plea agreement. Yeah, I don't think that you can waive that issue. And yes, I do think that it attached, although not raised in the opening brief. I do think it attached when the court made a determination that the plea was entered into knowingly, intelligently, voluntarily, and formally accepted the plea. I don't think that the issue is akin to what the state argues in their response, where they, I guess, kind of compared it to where the jury verdict is read and and it's not the correct verdict that's read. There's nothing in the record that we have, although it's a pretty limited record in that respect. There's nothing in the record that indicates that the court misspoke, which is kind of the analogy that the state made in their response on this particular issue, if I'm remembering correctly.
Is there any procedural requirement to raise for the defense counsel to speak up at trial, or at that time, and if not then, to pursue a special action to say, my client pled guilty, we shouldn't be going to trial?
I don't see a procedural requirement. I think defense counsel, trial counsel could have raised a special action, but I don't see anything that requires them to do that, or that maybe the issue is waived. Again, I just don't think that you can waive a double jeopardy issue.
Does that leave us, though, in a position where defense counsel can just sit there and say, okay, my client has pled guilty, but it's been withdrawn, so let's go ahead and roll the dice and go to trial, and if we have a bad result at trial, we've got a double jeopardy argument, and we'll just go back to the plea. Is that problematic?
Honestly, I hadn't thought about that.
I'm not suggesting that's what happened, but it seems like if we're going to allow, I'm not suggesting that defense counsel was thinking along
Correct.
those lines, but that's sort of what we're left with if we're saying the plea was entered and accepted, but we're going to allow defense counsel and the defendant to sit by and not dispute that the plea has been withdrawn.
I'm trying to think of.
Let's be clear on our terms. It wasn't withdrawn. It was vacated. I mean, she said, I'm vacating the pleas, which indicates that she had accepted it, the trial judge.
Correct. I'm in agreement that the trial court accepted the plea. I don't think it was, and I think I described it as a rejection, and I don't know why I did that in the opening brief. It clearly was a withdrawal or a vacating of a plea that was already accepted. But in terms of your question that you had asked, I don't think it creates that sort of issue where you kind of wait and roll the dice, and if it.
Well, what if he had been acquitted at trial?
Right.
Do we undo the acquittal and say, no, he pled guilty, the court didn't have any authority? That would seem odd.
Well, and that's actually what happened in this case. He pled guilty to a count that he was acquitted of.
Well, he did, but let's look at the
Right.
whole thing in context. The plea was far more favorable to your client than the day he had it sentencing.
Correct. And what if he was acquitted on all counts?
I mean, would we looking at the state and they would be standing here doing an appeal saying, oh, wait a minute, or a special action saying, wait a minute, he pled guilty, the court accepted it, jeopardy attached. So everything that happened afterwards, including the acquittals, are a nullity.
I don't know. This is all just kind of a mess. I'm going to be honest. It's all kind of a mess. I don't think so. I don't think an acquittal would then be able to be vacated at that point in time. But I do understand the court's concern.
Except you're kind of asking us to do that because you want us to reinstate the plea, and he was acquitted on one of the counts in the plea that was a term of the plea agreement, correct?
Correct. And that's why my request was to not reinstate the exact plea, but put the parties in the same position that they were in at that point.
Well, isn't that reinstating that that count?
But put the parties in a position where they can create a plea with counts that he hasn't been acquitted of.
Well, that seems inconsistent. If the court accepted the plea, it seems like we have to send it back and say, no, you have to sentence pursuant to the plea.
On a count that he's been acquitted of.
But
No, I don't
it was
think
only.
Oh, sorry.
I'm sorry, but so you're saying they have to get rid of that one and own the plea has to be, we're going to force the state to enter into a different plea agreement? Seems like if you look at it more globally, your client's much better off to just take if the plea should have been accepted, why wouldn't we just want to send it back for sentencing pursuant to that plea? If it was part of a global you're acquitted of some charges but convicted of this one, it seems odd that we would parse it out now. If either that plea was accepted or it wasn't. If it was accepted, isn't your client stuck at least with, okay, I'll go back and be sentenced under that plea?
Which is way more favorable than what he got with the trial.
Interesting. So just so I'm understanding, so the court's position would be that he's just resentenced, that you go back, the plea was accepted.
Well, it's not resentenced. He's never been sentenced under the plea. So he
Right,
would
I'm
just
sorry.
Be, and we're saying the plea was accepted. Therefore, you need to just go back and sentence him pursuant to the plea. That's not what you're asking us to do.
That's not what I was asking you to do in the pleadings that I provided.
What would be the basis for us doing something different?
I don't know. And I don't know that I have a strong opposition with the court doing that.
Counsel, it strikes me we're in a what-if world, right?
Correct.
Your argument, your substantive argument, is the plea was accepted and should not have been withdrawn. If that, by the court, if in that world, and we're not in that world, but in that world, the plea does the work. Nothing else, the trial never happens. There's a sentencing that is either consistent with the plea or is inconsistent with the plea. And if it's inconsistent with the plea, we get involved because something's wrong. But if it's consistent with the plea, case is over, absent a Rule 33 petition. It's never appealed. If I hear you right, though, your argument is, at least in the filings, is that there's some work that needs to be done to revise the plea. And I'm unaware of any doctrine that would facilitate a court being involved in such things.
And I'm in agreement with the court on this. I guess I hadn't contemplated not starting over with the plea proceedings. And so in drafting that sort of remedy, it was more of a looking at any other situation involving a plea. A lot of times if there was an issue, for example, in Donald, if there was an issue with the plea, or in that case there was an issue with the advisement regarding the plea, then you go back and start over with the plea.
Here your argument is exactly the contrary. There was no issue with that plea. You had no basis for not accepting it. It was
Correct.
accepted. You had no basis for revoking that.
Correct. And I'm not saying that they're analogous. I'm just saying that I've never seen that as a remedy, so I didn't contemplate it as a remedy. I don't see an issue with that remedy. I think that that may be an appropriate remedy under the circumstances, and that appropriate remedy, although it still really doesn't address the issue that you had, I'm not sure which justice had talked about with regard to defense counsel, I guess, rolling the dice if something like that happens. But I don't have a problem with the remedy of reinstating the plea or vacating the court's vacating of the plea. I don't know. And so the plea is in effect, and then the defendant is sentenced under the provisions of the plea. I don't have an issue with that remedy. I don't, in this moment, cannot think of a legal issue with that remedy. And while I proposed a different remedy, I don't see a huge problem with that. I hope that maybe answers some of the questions.
To Judge Catani's point on the dice rolling, it strikes me, but I'd be happy to be wrong in this, that the three participants in this plea proceeding, the trial judge, defense counsel, and the state, each could have done something more that would have prevented one way or the other the whole arguments here. I'm not quite sure why the Superior Court downed tools like it did. Defense counsel didn't make a robust record on what should have happened. The state, to their credit, said, hey, we've got an issue with the record, but didn't expand, and then really was kind of shut down by the court on what that issue might be. So we have this mysticism of what looked like a plea that the court, at least at one moment, found was knowing, voluntary, and intelligent, and was accepted. I share the concerns on the dice rolling, but my broader hope would be that this kind of record is never presented to avoid a whole bunch of things, including the delay with an appeal, a undoubtedly painful trial. So I'm not quite sure where that takes us, but this is a pretty unique case.
I'm in agreement. I haven't seen anything like it before. I don't know that there's a huge issue with dice rolling, and I think if the court drafted their opinion in a way that there are concerns about that, then that kind of puts the defense on notice that they need to make a record or...
The problem with that, though, is that if we're saying that you can't waive double jeopardy, it's that means you could roll the dice. I'm not saying it happens. The flip side of this is it seems like had the plea gone through, there could have been a Rule 33 proceeding where the defendant said that wasn't voluntary, there wasn't a good colloquy, it was clear I was equivocating. But here we've essentially resolved a Rule 33 issue because we know there wouldn't have been prejudice because we know what would have happened if we had allowed you to withdraw from the plea. So we've just essentially, I guess we could look at it that way. We've had a Rule 33 now and determined there's no prejudice. So either way, we were going to go to whether this was voluntary or not. But I still think it is problematic. If we're saying you can't waive double jeopardy, it does create this opportunity for dice rolling. Again, I'm not attributing that motive at the time, but definitely problematic.
Well, not to... At the moment, the court said, I'm vacating this plea, when there was no issue before it to do that. The state could have taken a special action if they didn't want to do a trial, right? Because they wanted to enforce the plea.
I think either party could have raised this issue on special action and didn't.
Just seems kind of unseemly. I guess unseemly is not the great word, but if you're the prosecutor and the defendant's not speaking up and saying, wait a minute, I wanted to plead, it seems like defense counsel and the defendant are implicitly agreeing with what the court's doing, and it would seem odd for the state to be the one to take the step to say, hey, let's go and enforce that plea.
Yes and no. I think both parties could have raised this issue on special action. I remember thinking that when I saw the issue. I think a lot of it comes down to not necessarily the fault of the defense counsel for not necessarily raising it. If you can see on the record, the state attempted to raise it, was cut off, then attempted to continue to make a record. I don't know that really created an environment where defense counsel was really going to add to, it seems, the court's frustration, at least unfairly reading between the lines with the length of the plea proceedings.
And I get that, but, we're now left with some pieces of a jigsaw puzzle that don't really create as clean a picture as we would hope.
I think that there's a lack of a clear picture, but I don't know that I would agree that it's necessarily the fault of defense counsel, thereby appellant, and so much the court for not really providing any information as to the reasoning for their decision. And that's...
You're saying it's not the fault of the court or the...
It is. I'm sorry. Did I say not?
No.
I'm sorry. I think it is the fault of the court that we have such a messy record because they didn't provide any explanation for why they decided to withdraw or vacate the plea. So I wouldn't necessarily fault defense counsel. I do think defense counsel probably should have spoken up in a perfect world, but I don't think that there was a requirement necessarily to do that. I mean, maybe this case will make a requirement to do that in the future, but I didn't see anything in the research that I did that required it or put the defense counsel on notice that this is something I really need to do in this moment. Again, Hindsight's always 20/20.
It would have been the better practice, that's for sure.
Correct. And so, does the court
And
have,
counsel, I
I'm
don't know if
sorry,
you were going to reserve time, but you only have a minute and a half remaining.
I'll reserve the remaining minute and a half.
All right.
Thank you.
Counsel?
Good morning, Your Honors, and may it please the Court. Joseph Began for the State of Arizona. As opposing counsel pointed out, we have already conceded on the third issue, and so this has to go back for resentencing no matter what. But the state maintains that the conviction should stand, as neither the ultimate withdrawal of Sanchez Rodriguez's suspect guilty plea nor the mid-trial amendment to the indictment warrant their reversal. Given that we spent most of our time, or most of defense counsel's time, on the first issue, I'll go to that issue first.
Well, let's start with the same question. Was it accepted? Did the trial court accept the plea?
From my review of the case law, yes. As soon as they say accepted and entered, is it accepted and entered?
She could have deferred.
She could have deferred. She was totally within her rights to do that. She did not.
Did anybody make a motion for her to vacate the plea?
No, although I do think that the state saying we're concerned about voluntariness here, although not a formal motion, is sort of telling the court, hey, we're really worried about this constitutional
Does the state have
requirement.
standing to make such a motion? Isn't that a defense motion? Saying, hey, wait a minute, I entered a plea, but it's not voluntary.
I think the state has an interest in bringing to the court constitutional issues that it sees. I think that by saying, hey, we're really concerned about this, the state is fulfilling its duty as an officer to the court.
Oh, I'm not faulting the state. I think it was very abundantly clear from the prosecutor's statements that she wanted a better record.
Right.
That's a different question than can the state ask to have that plea vacated?
It's a hard question, and I think that...
Isn't that pretty easy? If the defendant says, my plea is voluntary, I'm pleading guilty, the state doesn't step in at that point, does it? Does it have any right to step in and say, no, I disagree that it's voluntary?
I mean, let's go to the example where they have gotten information that this is absolutely coerced. I think the state should step in and say...
Well, they can raise the issue.
What?
They can raise the issue.
They can raise the issue, and maybe if the real question is, do they have the right to raise it by motion? I think that's a harder question. Should they bring it to the court's attention? Absolutely.
But that's not what we have here. I mean,
right.
It's one page of transcript.
Absolutely.
I accept it, Judge. We need to make a better record. I'm vacating it. Judge, that's not what I wanted. Shut up. I vacated. We're going to trial.
Right.
Didn't I synthesize? I mean, she didn't say shut up. That's my interpretation of what was going on.
Sure, of course.
But isn't that what happened?
I would agree that you're right. There's like a very poor record here. And as Judge Thoma pointed out, man, I wish we had a better record here. This whole case could have gone away. But I think, and I'm going to go back to Judge Thoma's point on this, the mysticism in the record, I think, is the fault of the defense counsel. They should have raised this issue and asked the court for...
What issue?
The issue of withdrawing the plea. They should have said, wait, no, you can't do that, or you shouldn't do that. And had they done that, perhaps the court would have said, you know what, I'm still not going to say anything, get out of here. And if they had done that, I think that would be a big problem in this court, and that would probably be a different question. But
so you're essentially saying the defense has waived double jeopardy.
I'm saying that they have waived, and to respect to the fundamental error question that you raised, it's waived and it can be reviewed for fundamental error unless they don't raise it in their opening brief or their reply brief. And neither of those were made here.
We can review for fundamental error.
Yeah, we do it all the time.
You are not supposed to. You can't ignore fundamental error if you find it in the record.
Well, and isn't that what we're suggesting? We have found fundamental error.
I mean,
Which you've conceded that jeopardy attached when she said it.
No, hold on, Your Honor.
You said, I asked, and you said yes. She entered it of record.
What you said, you asked me if it was accepted and entered.
Okay.
I don't think that jeopardy attached at that point.
Okay, well.
And I want to point the court to Santiago Soto, which we cite in our brief. It's a First Circuit case, admittedly, but it talks about this entering then immediately vacating posture and says jeopardy doesn't attach in that scenario.
Yeah, but it was a little different. And I'm going to trump your First Circuit and go to the U.S.
I love it. Yeah.
Go to the
Let's
U.S.
talk about
Supreme Court, and I'm going to quote it. Because of the acceptance of an unconditional plea is itself a conviction, like a verdict of a jury is conclusive, more is not required. The court has nothing to do but give judgment and sentence. U.S. Supreme Court, 1927. Now, I know the Supreme Court's reversing itself almost on a daily basis.
Of course.
But aren't we bound by that?
Well, I would ask the court to actually look at Ohio v. Johnson, which is a case that came out in 1984, I believe, and I can provide the site if you'd like it. But Ohio v. Johnson talked about whether it belies this idea that jeopardy attaches on acceptance. In that case, it talks about a defendant pleading guilty to a lesser included charge, and then says, but you can go ahead on the greater included charge. If jeopardy had attached when they pleaded guilty to those lesser included charges, there is no way the state could go forward on the greater included charges, indicating that that isn't quite right, that it attaches on acceptance of the plea. And so I would argue that the 1984 case.
I apologize for not.
Yeah.
I'm not. If you could go through that one more time. What happened in Ohio versus Johnson?
Yeah. So what happened in that case was the defendant says, I'm going to plead guilty to these two charges, lesser included of two greater charges that remained in the indictment.
Without a plea agreement, just stand up and say, I'm pleading guilty to these
With
two.
a plea agreement, and they don't say we're going to dismiss these greater
But
included
the state
charges.
hadn't agreed to dismiss them. He
Correct.
says, I want to plead to these. Isn't that very different than you had a global resolution with a plea agreement in this case?
So I think I have a couple of things to say to that. I would point the court and to the case United States v. Bruin, 991 F3D 652. If you want that again, I can give it. But that does a really good job of analyzing why that has to go to attachment of jeopardy and not to some other factor in the jeopardy analysis. In essence, it talks about how the court in that case goes to finality interests and prosecutorial overreach interests, which are the exact factors that the court considers when deciding when jeopardy attaches. And so Ohio v. Johnson becomes an attachment case if you look at it through that lens. And yes, I admit, it is very different from this case, and I'm asking this court to sort of go a little bit further than what Ohio v. Johnson literally says, but I think that that's a thrust of the case, and the natural sort of extension of that case.
You know, in Williams versus Superior Court, and that's the Arizona Supreme Court opinion, we have to follow them.
Of course.
Okay. They said, you know, if the court inappropriately vacates an acceptance of a plea and then schedules a case for trial, it violates the prohibition against double jeopardy.
So I don't have State v. Williams in front of me, so I apologize, Your Honor. But
It's Williams versus Superior Court. It's a
or Williams
special
v.
action.
Superior Court.
It's a special action where they inappropriately vacates a plea,
Right.
sets it for trial. Defendant takes a special action. Court says, nope, you accepted the plea. You go to sentencing.
So unfortunately, I don't have that case in front of me, which I wish I did, and so I could talk more intelligently about it. And I want to say two things about that. Number one, I think this is the problem with not having raised this in the opening and closing brief, or reply brief. We just haven't had a chance to respond in writing to this issue, and it would be really nice to have been cited State v. Williams, and we could have responded to that at the time. I think if this court wants to go down the double jeopardy route, it might be worth ordering supplemental briefing, subsequent briefing, so that we can actually hash this out in writing before this court. And I think the state would be happy to do that. But I do want to go back to sort of the origin of where that dictate comes from in Arizona Supreme Court case law. It originates back in 1980 with two cases, Lombrano v. Superior Court and State v. Superior Court. In both of those cases, the court accepted and entered the plea and then later said, I actually don't like the terms of the plea, so now I'm going to reject it. I think and that's very different from this case for two reasons. And I would guess that State v. Williams has a similar fact pattern, but I don't know.
But in those cases, I'm sorry.
No.
In those cases, they said the guilty plea is still valid. Jeopardy is attached. You want to reject the terms of the plea agreement. That's fine. You can. That's your right and privilege, Superior Court. But you have to give the defendant an opportunity to withdraw because jeopardy has attached.
So I understand that, but I do think, and this goes back to the whole card idea that we were talking about before, if there are involuntariness concerns, as I think there are here, do we really want to force the court, when they have those concerns, to go down and continue with sentencing and continue and hope that on a Rule 33 or Rule 32?
Let me just, sorry to interrupt you, but
Absolutely.
Let's say defense counsel had filed a special action and said the plea was accepted. What would the state's position have been?
I think the state's position would have been the same as it is here, which would have been, there are voluntariness concerns. We can go back to the plea agreement state. We can talk about it.
What's the voluntariness concern when the questions were asked, the defendant said, yes, I want to plead? Isn't a voluntariness issue something only the defendant can raise? And if the defendant's not raising it, what standing does the state have to come in and say, let's say you didn't have a history of the defendant having said something. Well, the state can't come in and say, well, we're glad you vacated that plea because we think there's some things going on that we might need a Rule 11 hearing or something. That would seem like an odd position for the state to take. Here it seemed like the state just wanted to make a better record
Right.
and make sure that it was voluntary. But if the defendant comes in and says, nope, that was voluntary, I want to take that plea.
I think this goes back to this idea of, I think you're right, the state maybe can't make that motion. But if the court sees it and sees that this is involuntary.
What did the court see? I mean, between line 16 and line 18, what did the court see that rendered it involuntary?
Again, I agree that this record is very thin, and I would argue.
It's not thin, it's non-existent.
But I think that there are things in the record to suggest that this might have been involuntary and are concerning. For example,
all of that, and sorry to interrupt, but all of that transpired before the court said, I find that this was voluntarily entered, and I accept it of record.
Right. And I agree, they say that, but courts have the inherent authority, and this is in case law, and I'm happy to find the case for you, to correct their mistakes. And they have the authority, I think, if you look at cases from other jurisdictions that talk about rules similar to 17.3, to continuously assure themselves of the voluntariness of the plea. And
don't they have to tell us that's what they're doing, as opposed to, I just don't like this defendant. I think the plea's too lenient. I mean, how do we know that's not what the court's doing?
I absolutely agree we should have had a better record here, and it would be better practice for them to do it. I don't see anything that actually requires them to do that. And there's case law in Arizona that suggests that discretionary decisions, they typically don't have to say why they're making them on the record. And there's no rule that says that.
How do we know that? I mean, a court, if the prosecution can't come in and say, we think this is an involuntary plea, we want you to set aside a plea agreement. Mm-hmm. The court can't do it either, can it, without, on its own? It seems like that's a uniquely within the province of the defendant and defense counsel to say, no, even though we said we're taking this plea, we're pleading guilty, it wasn't voluntary. That seems like an odd position for the court to be able to just come in and say that without explaining why.
Well, look, again, I agree they should have said more. We can't get around that at this point. We have the record we have. I don't think they're required to say that. And I think the state would maintain that as long as we can look at the record and see that there is support for what they did, then it's okay, particularly when it's not raised below. And there are cases that suggest that it is on the defendant, is their burden to sort of make a complete record. And if they don't, on fundamental error review, they can't show error, and that's their issue, not ours. And so
And counsel, to supplement though, and the state's attorney started down this path but didn't get very far. You, I think, have conceded that the state has no authority to move to withdraw from
Right.
a plea like this. But the state does have a vested interest, a good interest, in making sure the record supports the actions that are taken by the Superior Court.
Agreed.
And there was a beginning of an attempt there, but the hearing ended sort of very quickly
Right.
after that.
Well, she attempted to have the court make a better record, and the court disregarded that attempt and just vacated the plea.
Right. And I think that if the defendant had a problem with that, they should have said something. They should have said, Your Honor, I don't understand why this is happening. But quite to the converse, not only do they not raise it, in later filings, they seem to understand why this all happened. And again, we're on a cold record here, right? And we're talking about this very cold record. But it seems defense counsel understood, right? Later they say, the trial court declined to accept his change of plea pursuant to a plea agreement based on defendant's statements that would indicate that Mr. Sanchez did not understand what was going on. I think that that's also very important, because again, it shows that people who were there understood why this was happening. We're reading this record. We don't, I can try to puzzle it out for you. I can point to the 2 times he pleads not guilty. I can point to his equivocations, but we weren't there. None of us were there.
Isn't one, and I understand your position on that, but isn't another way to look at that, the trial counsel was trying to do the very best he or she could with the cards that they had on the table at the time?
I think I would disagree. They could have easily said, we have concerns about, competency if they wanted to, but they didn't have to represent what they thought had happened at a previous proceeding.
Well, except we don't, we don't behind it being a waiver just because you change strategy in midstream based on rulings. So why would we do that here?
But there's no evidence of that. We are trying to, again, we're all trying to figure out what happened at this proceeding. And yes, it is possible they changed their strategy, but we're doing our best to recreate the record, and we have to make inferences in favor of affirming what happened below.
That may not, only if the record supports it, but if we say, the defense attorney was wrong, he should have objected or made it, and we're placing the blame on the defense attorney, aren't we just right back to an ineffective assistance of counsel claim? And we're right back to whether jeopardy attached at that moment and whether he was entitled to be sentenced under the plea agreement.
Well,
because it clearly is a different result.
Then we go to post-conviction proceedings, and we're looking at the record with deference to the trial court who looked at it before. And at that point, we have to say, well, did they abuse their discretion in making the decision that they did? Probably not. But my concern is the opposite. My concern is we have very serious voluntariness concerns, but the defendant's not saying anything, so we're just going to go. We're going to go all the way through to sentencing. Then we're going to go to post-conviction, and they're going to say, that was involuntary. The court's going to say, well, I see that you said this. I see that you saw that. You said yes on this, yes on this. Yeah, you were equivocating, but we're on abuse of discretion standards, so I'm just going to defer. The trial court was the one who saw it. So I think my biggest...
It seems like you would have a very valid ineffective assistance of counsel claim to say you should have objected, I should not have gone to trial, jeopardy attached as soon as I pled guilty. Wouldn't I could have, I guess if you're saying defense counsel, I guess what I'm misspeaking here. It seems like if they had accepted the plea, we go forward, and then in the PCR, defense says, oh, that wasn't voluntary. I should have, you should have gone forward. At a minimum, he's going to have to show there would have been a different result had I gone to trial, which is what we've now done by going to trial, and we know there wouldn't be a different result. So it seems like we were going to kind of get to the same place either way, whether it's through a Rule 33, if we're going to say, there were some pretty obvious things going on that made it look like I was not competent and didn't understand what was happening. So why is it a bad result if we just say jeopardy attached and go be sentenced under the original plea? He clearly will not have a viable Rule 33 claim at this point.
Of course, and I think ex post in this case, I agree. I mean, we think that jeopardy didn't attach, and we think that the result that it actually came out to after a jury decided this case is better. But I think we have to think about this ex ante, right? What is going to happen in future cases where the judge thinks, oh God, like I'm worried about voluntariness in this case. Should I just let it stand even though I have these voluntariness concerns?
Well, she could always just defer acceptance and explore.
Of course.
But
And again, we all
we are
agree.
telling a trial judge you can't do that without making an explanation.
And if the basis of the ruling is that you want a better explanation, I don't think that really finds its support in the case law or the rules. But that is one way to make the
Well,
decision.
we're not saying we want a better explanation. We're saying jeopardy attaches when the plea is accepted, and unless someone has moved to withdraw, the court could have at a minimum asked defense counsel, "Are you satisfied that this is a voluntary plea?" And made a record at that point. If we say that, we're not creating a hornet's nest.
Or, counsel, is there anything else to add from both sides of the courthouse? I mean, that would have made a great deal of sense.
Of course,
Is it
yeah.
good
And
practice?
I cannot emphasize enough. There are better practices and better things could have happened below.
From all three involved.
From all three of them.
I see your time is
Yeah, my time is up. So
Thank you.
I would ask that you could affirm the convictions, but remand for resentencing.
Can we give the appellant an additional minute, please?
Could we ask him though? Do you disagree with their suggestion that we have to go back and do a different plea if the initial request was to send it back and put the parties in the position of renegotiating a plea?
No, so I agree that in this case, we act as if the second jeopardy never attached. We go back and the plea is reoffered, and that's the plea that they're stuck with, and they can sentence on that. There's a Ninth Circuit case on that, Patterson, but I don't have it in front of me. That would be the state's position.
Thank you.
Thank you, Your Honor.
Counsel?
So in my very, very quick review of Williams v. Superior Court, it appears that the remedy that the court has suggested, it looks like that was the same remedy that they took in that particular case, which the facts seem to almost mimic the facts in this case a little bit differently in that they didn't show up for sentencing. But in quickly reviewing that, it appears that the remedy that the court suggested, which is that the vacating of the plea is vacated and then they're sentenced under the plea agreement, seems to be the appropriate remedy. So I would defer to that remedy in this particular situation. I'm in agreement with the court that should this case go forward, we're going to end up with a Rule 32 coming up on a lot of these issues. And so I think the appropriate remedy in this particular situation would be to, under the first issue, to vacate the vacated plea and sentence appellant under the plea agreement. With regard to the voluntariness concerns, obviously, I've outlined that in my reply that I don't believe that the voluntariness concerns are clear from the record. And I don't think that the rules allowed the judge to do what the judge did. I think even if the court would have had to make a pretty serious record to be able to do what they did. I couldn't find any rules that really allow the court to vacate an accepted plea. And so I think that that's problematic as well. Thank you. Anything else? Okay.
No, thank you very much.
Thank you.
The matter is deemed submitted. We'll issue a decision in due course. Thank you very much for your briefing and your argument here today. The court will be in recess and allow for the next case to be prepared.